that you just don't protect consumers but suppliers as well. So briefly, help us understand the concept of abuse of buyer power that leads to, bad contractual agreements that is detrimental to some suppliers' businesses. Yeah,
abuse of buyer power relates to the relationship between suppliers and buyers. Suppliers and buyers, in this sense, there has to be some form of contractual agreement, and there's evidence to that effect. One of the things that we establish first before we go into investigating and penalizing abuse of buyer power is to look at, is there any relationship between these two parties, retailer and a supplier? Once we receive that complaint, we go and find out and also invite parties to see if that practice exists or if they have a relationship. If you have provided evidence to that effect, then we invite both parties for an hearing to find if there is a relationship between the two, not only from one side, who is supplier, but also looking at the side of the retailer. Then we are able to weigh our decision based on the evidence before us. They indeed actually have a relationship in terms of buyer-supplier, and who has more power in terms of market dynamics, and therefore who is on the wrong in this case as per the law.
Okay, that's interesting, because it's much needed reprieve, especially to supplier issues that we've seen in the country playing out time and time again, knowing that there's an authority that looks critically into that and provides a solution. But let's talk about the big figures in terms of hefty fines. During the introduction, I just mentioned one of the retailers in the market who, of course, appealed that decision. But what captured the attention of the masses was that, is it the 1.1 billion fine that was imposed? So just looking at the hefty fines that are imposed on market participants who are found contravening the law in one way or the other, how exactly do you get to that figure? We've read some of the law, what it says, 10% of the turnover since the maximum penalty CAK can oppose. It's only 10% what you can impose. How do you get to such a figure? What is a contributing factor?
In this particular case, what happened was there are two complainants, and both of them, they are suppliers to the retailer. And we did investigation and we established that indeed, yes, they have a relationship between supplier and the retailer. And therefore, based on the evidence, the law allows us to penalize up to 10% of the preceding year turnover as to when we made decision on the matter. So that decision was made at a time when we established that the previous year's turnover of the retailer. Now, based on the number of complaints and the products involved, we were able to establish 10% of the retailer is actually less than what we charged. So in determining the penalty, as we call it, is there are two factors which we consider. One is aggravating factor that are potentially leading to that conduct. We look at the issue of impact of the duration of the effect on the market, the size of that undertaking, and also in terms of have they committed similar conduct in the past. Then now we go to the mitigating factor. We also consider factors which are potential reducing effect in terms of the retailer. We not only look at aggravating, but also look at mitigating factors. What can reduce that effect? So the 1.1 billion you mentioned is not actually 10% of what the law allows us to penalize.
It's actually less?
It's actually less. So indeed, that's what we established. There's evidence between relationship of supply and buyer, and then there are a number of products involved, and therefore on that account, and also basing the penalty on the preceding year's turnover, we're able to arrive at that figure, and which we also communicated to the retailer way before we made that determination and pronounced ourselves.
That's well noted. And as we finalize in a minute or two, talk to us about the function of advocacy and advising government, because you can exercise hard enforcement, but you can equally exercise soft power in terms of enforcement of laws. Talk to us about it.
Yes, this is correct. In terms of, we are not predominantly punitive authority. There's hard enforcement, which is now to do with enforcement in terms of penalties, once we have determined a decision, and also there's evidence that effect. The other aspect is actually soft enforcement. Advocacy is one of those tools that we use. Last week, we just ended one of advocacy workshops, and International Competition Network here in Nairobi. The soft enforcement is powerful in the sense that it allows us to communicate to different stakeholders, different players about the provision of competition law and also consumer protection issues. With that information with them, it allows them to comply with the law rather than violating the law, which is anti-competitive, and in a liberal market, anti-competitive behaviors are not allowed. Therefore, actually, advocacy, as you correctly put it, allows players of different kind to comply with the provision of Competition Act and consumer protection.
Well, it's definitely a timely conversation on competition law enforcement in Kenya, because mind you, just last week they launched the Competition and Consumer Protection Law Digest book, all in a bid to inform the public on this all-important matter, well, to do with competition law enforcement in Kenya, which is part of the mandate of the Competition Authority of Kenya. I was joined in studio by Dr. Adano Wario. Thank you so much for your time. He's the Acting Director General of the Competition Authority of Kenya. Make sure you're well and conversant with this, because this is a body that protects your rights as a consumer. We take a short break, but coming up.
Just ahead in business,